Labor law is a body of law whose subject is the employment contract and the legal institutions that surround it, which includes the right to privacy of both employees and employers. Employee privacy rights cover and limit a worker's personal information and activities at work, keeping them private. This is important for employees for reasons such as limit on power, freedom of speech, trust, respect, control over one's life, and freedom of social and political activities. The Constitution of Spain sets the baseline of each citizen's right to privacy. Section 18 of the Constitution states that personal and familial privacy are guaranteed. This includes the sanctity of the home, as well as the secrecy of communications, and restricts the use of data processing to guarantee personal and familial privacy. Article 1 of the Organic Law of the Right to Honor and Personal Privacy states that each person's right to privacy is irrenunciable, any waiver is considered null, inalienable, the impossibility of transmitting the right of third parties, and imprescriptible, which means no statute of limitations. The workers' statute translates the law set forward by the Spanish government into labor law terms. All workers, according to Article 4 in the workers' statute, have a right to privacy and consideration for their dignity. Workers are protected against harassment as a result of race, ethnicity, religion, disabilities, age, as well as sexual orientation and sexual harassment. The Handbook of Spanish Employment Law defines the boundaries of privacy in the workplace. Employers may be able to monitor their employees' conversations, communications, and correspondence. However, this can only take place if the employers make it extremely clear to their workers that they have legitimate reason for doing so and that the workers know that it's happening. One example of why this could happen is to increase worker productivity. You must let them know that they're being videotaped in certain places, phone calls may be recorded, or that computer activity may be monitored. One example that we covered during class that illustrates this topic is the extent to which employers can monitor their employees without violating their fundamental rights. We analyzed a case of whether an employee had the right to hire a private investigator to take pictures and videos of an employee during work hours on the suspicion that the employee was working for their competitor during work hours. Through the proportionality test, a 4-stage test which tests whether human rights are violated set forward by the Spanish employment law, we found that the employer's action was justified. The reason the employer's action was justified is because it passes the 4 steps of the proportionality test. The first step passes since this is a legitimate and compelling issue if their employee works for their competitor during work hours. The second step passes because surveillance is the only realistic way to achieve this goal. The third step should pass because of the severity of the issue. However, it is not as clear-cut since it could disrupt the privacy of the employee. And the fourth step certainly passes because figuring out whether your employee is working for a competitor during work hours is very important to the overall cause. In conclusion, the right to privacy is a fundamental right for all employees. Employers must follow and respect the laws in place regarding the privacy of their employees. However, if an employer believes that their company is in jeopardy of being hurt by an employee, there are ways to monitor the actions of employees.